What happens when a state passes a gun law that directly conflicts with the Constitution? Do they get challenged in court years later, or does the federal government step in immediately? Well, if you're from New Jersey like I am, you know that unconstitutional laws, especially gun laws, typically get challenged in court years later. But in this video, I want to talk about something that's happening right now. It seems to be a shift in how these bad gun laws are handled going forward. So let's get into it. For the first time, to my knowledge, the Department of Justice is saying they're not just watching what states are doing, they are actually preparing to act. Here's what I'm talking about. Recently, the Department of Justice, specifically the Civil Rights Division, sent a formal warning to the state of Virginia regarding a series of proposed gun laws. These included restrictions on commonly owned semi-automatic firearms, including AR-15 style rifles. Now here's the key point. This wasn't just an informal inquiry. This was a formal notice stating if these laws are signed and enacted, the Department of Justice is preparing to take legal action. That includes filing lawsuits and seeking injunctions to stop enforcement. To me, that's a big deal. Now, to date, I don't think the governor of Virginia has signed these laws. I think she sent them back to get revised, but to my knowledge, she has not signed these laws yet. It appears to me that the federal government, at least the current federal government, sees Second Amendment rights as civil rights, and they're saying, we're going to enforce them that way. I think this is interesting because it's not just about Virginia, it's really about strategy if you think about it. So let's start with what this move actually represents. So this is the federal government stepping in early. They're not waiting 5 or 10 years for a case to work its way through the courts. They're basically putting states on notice up front. That changes the timeline and it changes the pressure, right? Because now lawmakers know if they push a law that clearly conflicts with established Second Amendment precedent, they may be challenged immediately. Now, to some, it may not matter. They may pass the laws or write the laws anyway, but to others, I think it will matter. Some might ask, why is the DOJ, a federal agency, concerned about what's happening in a state like Virginia? I think it's part of their strategy because they know that most of the major Second Amendment victories that we've seen have been against state or local laws. So think about District of Columbia versus Heller, McDonald versus City of Chicago. Of course, the latest New York State Rifle and Pistol Association versus Bruen, otherwise known as NYSRPA versus Bruen, and that was June of 2022 when they came out with their decision. Each of those cases addressed restrictions coming from states or municipalities. And in those decisions, the Supreme Court reinforced a consistent principle. If a firearm is in common use for lawful purposes, it is protected under the Second Amendment. That's the standard. Not whether someone likes it, not whether it looks or sounds scary or a certain way, but whether it is commonly owned and used by law-abiding citizens. And that's exactly the argument being raised here. When we talk about common use, this is where the AR-15 discussion comes in, because I feel like a lot of politicians, anti-gun politicians, target the AR-15. The DOJ is pointing out that these are among the most commonly owned firearms in the country, tens of millions in circulation, used lawfully by citizens across the United States. Under the framework established in Heller and of course reinforced in Bruen, that makes a huge difference because the burden is not on the citizen to justify ownership. The burden is on the government to prove that a restriction that they of course have come up with is consistent with historical tradition. And as we know, that's a pretty high bar. A lot of these states are failing when they're challenged in court and they're saying, show us where the tradition is to back up your restriction, and they can't do it. If you live in New Jersey, you're already familiar with very strict gun laws. We have an assault weapon ban, we have magazine capacity limits, we have sensitive place restrictions, which amounts to most of the state. We have complex carry regulations, including mandatory training requirements. And many of these laws are already being challenged. We've done videos on them, and currently there are some appeals processes that are still pending. So I think the question is, if the Department of Justice is willing to step into a situation like Virginia, what happens if similar legal challenges happen, like say, for example, in New Jersey. New Jersey decides they're going to put forth a whole new set of gun restrictions. So, of course, we have to be realistic. This does not mean that the DOJ is going to sweep in overnight and change everything. We all know that that's not how the system works. The courts still decide these cases. And as we know, litigation takes time, sometimes years. And not every law gets struck down, right? Sometimes only part of a law gets struck down, not the entire law. We've already had preliminary injunctions and parts of the New Jersey anti-carry law that have been struck down because the court has decided that that part of the law has virtually no chance of winning a challenge. But what it does mean to me is this: there may be increased federal scrutiny and potentially faster legal responses when these states like New Jersey, Virginia, New York, California, you know the list, pass these laws that push beyond constitutional limits and clearly conflict with the Second Amendment. From a law enforcement and investigative standpoint, I can tell you this for sure: clarity in the law does matter. When laws are constantly changing and shifting, or when they're written in ways that conflict with established precedent, it creates confusion, and not just for citizens and law-abiding gun owners, but for police officers and prosecutors and for the courts. And ultimately, of course, that's where the cases get decided. So here's the bottom line. Obviously, this move by the Department of Justice is not the end of the Second Amendment fight. But I think it is a signal. I think it's a signal that enforcement could be shifting, a signal that state laws are going to be challenged more directly, especially in states with really strict regulations. So if you live in New Jersey, this is something that you need to pay attention to, because I've said it before, what happens in other states has a way of eventually impacting what happens here and in other states. NYSRPA versus Bruen is a perfect example. That was a New York case, and once it was decided, New Jersey immediately changed their carry permit requirements. Of course, they also came up with an anti-carry law that's still currently being challenged, but the point is that U.S. Supreme Court decision from another state, New York, caused New Jersey to change their process. If you want to stay up to date on how these legal changes affect you here in New Jersey and across the country, make sure you're subscribed. And if you want to take it a step further, check out my book, Defend Confidently, and my online course where I break down how to stay safe, prepared, and responsible in the real world. Stay safe, stay aware, and I'll see you in the next one.